Someone make it make sense.
Probably a couple.
Hello, everybody. Welcome on in. Happy to be back with you guys to get all caught up on all things Karen Reed. We've had some crazy weather here. We're on like flash flood warnings, and it's been thunderstorms, and so hopefully the internet will hold up and everything. Apparently, there's also StreamYard's been having some issues for some other people as well. Hopefully, everything will go smoothly with that today. But if anything happens, just know it was probably the weather. Welcome, Bunny. Happy to see you again. Excellent. So Bunny says, I win. Yes, you do win. First in the chat, which reminds me, I need to send Twiz his special text because Twiz is, well, special. So we are going to pick up right here with the charging conference from day 32. There are a few surprises you guys may have already seen, but we're going to make our way through that. And yeah. Here we go.
Now open, you may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor.
Good morning, Ms. McLaughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Thank you for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Kennedy from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little? Okay. All right, so first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for
Dr.
identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for required finding not guilty of close all the evidence.
So no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
Okay, so this is basically, I forgot about this. This is basically a motion for a directed verdict, or if you're in Florida, a judgment of acquittal, and they have their own name for it in Massachusetts, the required finding argument, but that's what this is basically arguing for dismissal.
And this is not lengthy, Judge, 5 or 10 minutes.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death, a dog which mysteriously was absent from the home at 6:30 in the morning on January 29th when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept, a dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that the evidence is inconsistent completely with the Commonwealth's theory of the case, that's exactly what we have here.
Agree more.
But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method.
Yeah.
Dr. Welcher actually
Well,
did the proper force analysis.
And also, to be honest, Brian actually said so much himself that it was a meaningless experiment, right? So,
and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sallyport, the taillight was merely cracked. When he was shown photos of what it looked like in the Sallyport after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakith has confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Alberts who was on video, hot, angry.
You just said Albert, you mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who was on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Alberts residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right, thank you.
here we go. Here comes Breenan. Or no, not right. Here comes Wally. Oh, wow.
Thank you, Your Honor. Commonwealth requests that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog. There is no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't
What?
see it in the morning, which does not equate to there being an absence of a dog there. The argument from counsel of Commonwealth would suggest grossly exaggerates the strength of the defense witnesses and their
the new theory from the Commonwealth. Chloe never existed. She was a figment of your imagination.
case. The bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. A couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave indicated the damage to the tail light was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video and photographs within the Sallyport. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. Laposada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the the cruiser camera video drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief.
Wow.
There's been nothing presented in the defendant's case to diminish, particularly to the standards in the light most favorable to the Commonwealth, and request that the defendant's motion be denied.
So Christina, you know I have to hear this in the
So
light.
that's a good point, Meg. Meg's saying that the state said that Chloe was rehomed to read to Cora. Poor Chloe. While that may be true, Lolly didn't even say a name. He didn't say Cora or Chloe. He just said there's been no evidence of a dog ever existing or didn't exist, or like literally there is no dog. Pretty wild.
And viewing it that way, the Commonwealth
Has met its burden, so the motion's denied.
Thank you.
Okay. All right. So regarding the charge, so we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor, and I apologize. We made the decision last night to withdraw 2 of our requested instructions, which would shorten things today. I think it's
Oh, okay. So
That was the first big surprise of the day. They are no longer requesting the missing witness instruction.
everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction. You're withdrawing that?
with regard to the absent witness instruction, we're withdrawing that request.
Okay. And what else from your proposed instructions? You said there were 2. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right,
Interesting. Lost or destroyed evidence.
thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of this sweatshirt.
Oh, that's right. I saw it in email. I don't have a hard copy of it.
That's just the lesson.
Your Honor, if it's
Now-
all, Your Honor, I'll hand up my hard copy.
This one we already covered because we read it before Judge Bev had a chance to talk about it. So we read this on the previous live stream.
If you could do that, I'd like to go back through the rest of it and come back to that after I've read it, okay? Who's arguing for the rest of the defendant's proposed instructions?
I am, Your Honor.
Okay, so we're gonna go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yeah.
All right, so model homicide instructions and just as last time. So that takes a lot of time out of today.
The only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand the court's position might be on this, but as far as the instruction related to murder charge, the Commonwealth is only seeking instruction on murder problem.
All right, so we will deal with that. I'm going to go through the defendant's instructions or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so
Why do I find that hard to believe, though?
we'll probably, okay.
So she's like, I'm not even going to tell you what it is. I'm just going to assume I just want you to assume that I'm correct and that it's better and that I'm just going to swap it out. Like, what? Mine's more robust, so we're just going to use that. Pardon you? On the presumption of innocence?
And I will give some version.
Doesn't even. Okay, the way these things normally go, guys, with these charging conferences, or as it were, or jury instruction conferences, is that they actually spend time on it. Like, both sides have their proposed instructions, and sometimes the court has a proposed instruction, and it's a process. In every other trial, except for with this trial, and same with last year, right? Where they go through it, they argue, they go back and forth, they make changes, and then there's a draft given, right, to both sides from the judge. Here's what we've got, and then they go back again and they make any other changes. And basically, both sides have an opportunity to see the finalized version before they've agreed to it. And when both sides have agreed, and here's the finalized version, then that is what is put before the jury. That's not the case here in Massachusetts. So,
And I know that there was a lot of
I
attention
will give some version. I mean, this is what we're dealing with here, right?
paid and some appellate decisions on the each individual
Right? I know.
indictment. I'll give some further language on that. You've got an instruction and proposed on page
Some
4,
language.
reaching a verdict. Just-
Some language. Objection vague, 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 vague. Every single thing is vague.
I will make it crystal clear, though. I think it was, and I was upheld on it. So I will make.
What now?
further language on that. You've got an instruction to propose on page 4, reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld on it. So
they're saying it wasn't clear enough. We want it to be clearer, right? We want the language to be clearer. And she's saying, yeah, I'll make sure. What does she say? This is so stupid. I hate her so much. I'll give some, where is it?
further language on
I'll
that.
give some further language. But then she walks it back by saying it was clear last year and I was upheld on it. So what? It's like pretending like she's going to at least do something, right, with clearer language, but then saying, no, there's no need because I was right. I was upheld.
You've got an instruction to propose on page 4,
I'm glad.
reaching a verdict. Just, I will make it crystal clear, though. I think it was, and I was upheld.
I'll make it crystal clear as if it wasn't previously. So she says, I'll make it crystal clear, although I think it was. Like, sorry, not sorry? I mean,
On it, so I will make it crystal clear. Okay, so I'll give you that, Ms.
make it
Giannetti.
crystal clear, like you think it was last year, which it wasn't. So that does not give me great confidence.
This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti,
Why can't you provide, though, a draft of what you intend to do?
you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Ron.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
And I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden.
Okay.
I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction, third party incorporate, but the Commonwealth will be making similar requests that counsel be prohibited from making a third party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit.
So this is where it gets interesting, right? Because we know there's a little bit of overlap between the Bowden and the third-party culprit. And so here it's going to be outlined specifically as to what they're going to be able, how they're going to be able to phrase this for the jury in closing and how the jury will be instructed.
Submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third party culprit in this trial has come from questions from defendants, not from actual evidence in the case, not from testimony from witnesses who stand, exhibits that would witness evidence or anything of the like. So in the instruction and arguments are based or predicated on evidence. And obviously, the court is well aware there's a specific instruction that no matter how powerful they are, questions to counsel are not evidence. So what the Commonwealth will submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only Bowden or third party culprit instruction, but specifically for even counsel to make that argument during the course of closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Mr. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate materials to pack the evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias, the investigator failure to pursue the suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it,
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. Mr. Giannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, that you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert.
Correct.
So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and we're strictly going with a Bowden defense.
Okay, so you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I understand. That's what's over there.
Okay.
That's really what I was saying, just clarification. based on the
Yeah. So Mr. Yannetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, Commonwealth does have an objection to the DTU instruction. That's at the top of the data.
Yeah, I have a check mark next to that. Mr. Yannetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
Right. So, obviously, it's not the strongest DTU argument that we would have. It would not occur at a police station. But, these days, Your Honor, it's common knowledge that everybody has access to a recorder, even on your own cell phone. It could have been done. It wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording. So we still think we're entitled to
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounded with her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it could be considered custodial.
All right, what do you say about all this, Mr.
And
Hill?
if I would also add, Mark,
Sure.
they did seize her vehicle at around the same time. So, that it goes to, I think, the issue of custody and my client being able to deny it.
All right, what do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the juror spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, throughout the course of that. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from eating. And it did not end in any sort of custodial situation. She was taken into custody, she was arrested. Yes, they did seize her cell phone and her vehicle.
I think he gets easier to hear a little bit later.
From Ms. Reed himself. But I don't think that transforms that conversation or interview in her parents' living room into a custodial interrogation. The bigger issue that I have is placement, as far as there's already been within the same requested jury instructions or requested jury practice. And then following the DGMP's language and the requested jury instructions, there goes on to all of this other requests regarding your compromised mental state and all of these other things that, while if it were to be given by the court, should be given in the same context between practice. I don't think it's something that should be highlighted in two different sections. I would submit that there is no evidence of her having a compromised mental state or anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and having testimony from the stand, that initially she said she wanted to be fine with answering questions, but they wanted in many details. And then when the questions became centered on, or more centered on
She's
details,
blocked
at
or?
that point, I know that's not a good jury, but of course, where she then ended the questioning at that point. So I don't think there's any evidence of her having a compromised mental state for the course of this interview.
So at least we've got CCs here.
I don't think they rise to the level of the instruction. So
Since it sounds like they're underwater.
I would ask basically that everything on page 8 prior to the Bowden instruction be excised.
All right. I'll take another look at this and I'll just let you know in the morning.
I mean, unacceptable. Absolutely fucking unacceptable. I'll let you know in the morning when you go to do your closing arguments.
We agree that would not apply to the interview at her residence. but we believe that it applies within the humane practice
That
context.
is where it makes sense. So, all right.
If it's going to happen, it should happen once, not.
I think that's fair.
Okay. Okay.
I mean, the thing is, this is in the morning on, what was it, Thursday, right? You know, they knocked this out in an hour and a half. Well, actually, not even, because, you know, the first bit and I'm sure the last bit, they're not even here. It's like, I'll let you know in the morning, last minute, versus like, let's take a break and then I'll let you know what the fuck's going to happen for jury instructions. It's just, oh, she tests the patience, doesn't she? Hi, Flash.
All right. Prior statement, I will give some instruction on prior inconsistent, and
I'll
I'll
give
give a
some instruction. Okay, great.
prior consistent
That's good.
statement. I will talk about the view. The absent witness instruction is withdrawn. So is the,
Not to interrupt.
That's okay.
With
that's okay.
regard to the view, Your Honor, we did include a language reinforcing the fact that the rock that they saw on the view
Oh.
was not present on January 29th. We asked her to repeat that one sentence.
Okay. So I did not see this when I took a quick look at the view. All right. I'm not going to repeat it.
I didn't see it when I took a quick look. Well, because you didn't bother to read it.
All right. Lost or destroyed evidence you're withdrawing.
Yes.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just reference that.
Sure.
Language in there that I rejected.
Okay.
That's what a police officer or someone else works for a law enforcement agency.
What do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
I'll do police officer because they're police testimony. I'm not going to go beyond that. Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will I'll cover all those topics. What page you on? Okay.
One suggestion there was indicates now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
Guys, remember last year how like both when she was reading the final jury instructions, sorry, quote unquote final jury instructions. Do you guys remember how in both the jury instructions and obviously the verdict slips, there were issues beyond even the issues that we know of with the verdict slips? There were like numerous typos and issues like that with the jury instructions and the verdict slips. It's just unacceptable. And I just don't understand why. Like, this is the most important part of the entire thing because you're sending the jury off to deliberate. And I just don't understand why. I just don't understand why she does it like this, guys. Especially when you've slated the whole day. You've cleared the whole day. This entire day was cleared. Hi, Happy Annie. Welcome.
Yeah, so I would just say you've seen photographs. Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it. So I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give. All right. So the Commonwealth's request is sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to your, it's not numbered, your supplemental instructions, use of a dangerous weapon. All right. So I'm going to give that, Ms. Giannetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Yeah.
All right.
Some
So
version.
I'll give,
Yes, that this for literally everything. Some version, some version, some version. It's like the point of this conference is to determine what version. Like that's the point of this. This is craziness, guys. That's the point of this. Is to determine which version and put it in writing for both sides to agree on.
probably what I gave last year, and this looks like it's it.
Painful.
What is not evidence, evaluating. I'm going to give what is not evidence. Evaluating the evidence. There's some instruction. Ms. Giannetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks.
Okay.
And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Yeah, we're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth request for that instruction.
All right. Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional impact photos, humane practice. We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it that. I gave a prior bad acts instruction before that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Bins in those cases.
Commonwealth versus Bins. Can we just chuck her in the bin, as in the trash bin? Sorry, that was maybe a bit rude, but I feel kind of like it's warranted with her. Mary's back. Love it.
I thought it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified. Okay. All right. So did I give it any other time that there's another event that I should highlight? I don't think so.
Yeah. I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. It might be covered enough when I give the electronic communications instruction. So I will think about that. All right. Those were the limiting instructions I wanted to get to. So
we would object to the part of that accident linked to the Higgins text message.
all right. I'm going to take a look at that, Mr. Lessie. All right. Consciousness of guilt.
You're on call.
Okay. All right. All right. So tell me where the difference is in what I gave last year from the model homicide instruction on second degree murder and where
I know.
you're saying I should not this year, Mr. Lally.
So the only,
1 second. Let me just pull that up. Okay.
She asked him to go ahead and speak, and then she's like, hang on, I'm not ready.
you're on call request severely not for any change or alteration in instructions that were given other than there are 3 prongs of malice. And essentially, the Commonwealth is requesting that the jury
Liz, don't jinx it.
merely on third prong malice, because that's the only one that really applies to these factors.
Okay.
I mean, I just have to say, well, I don't want to jinx it. Like, here's the thing. Well, you know what? Let's not get ahead of ourselves. We'll talk about it because we're going to go through all the charges and the verdict slips and all that because there's some changes from last time. We're going to go through it. Okay.
Commonwealth here, the
I'll
first
get ahead of
prongs are essentially strange in this situation and avoid confusion.
Do you have supportive case law for me to single this out?
Look at Breenan with his laptop. What's he? I wish we could see what he's doing over there. You know, if he's working, if he's working on his closing argument speech, I bet it's just one word and then he's just copying and pasting it 1,000 times. And that one word is inevitably, and that's all he needs.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm, and she did not intend to kill him. It was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at a position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement.
What they're talking about here, I know it's like impossible to hear. Here's what they're talking about, guys. Let me pull it up. What they're talking about is defining murder, second-degree murder. So kind of important. So where is it? Am I in? Oh, I'm not in the right folder. Hold on, guys. Sorry. Karen Reed folder. Duh. Okay, give me just a sec to unshare, reshare. Okay. Come on. My God, it's just going to be impossibly slow. We need page 50 of this thing. Okay, so here's what they're talking about, right? Okay, so they're talking about wanting to remove A and B, right? That the defendant, so here's A, the defendant intended to kill, insert victim's name, or B, intended to cause grievous bodily harm to insert victim's name. They're talking about only giving part C, which is the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. This is still kind of getting into that realm of like the chain of events, right? There, to me, there's a big difference, right, between like A and B and C. Let me read this again. So here's the standard instruction for second degree. The defendant caused the death, right? That's number one, fine. Number two, the defendant, A, intended to kill, insert victim's name. B, intended to cause grievous bodily harm to, insert victim's name. Or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. So what the Commonwealth has asked is to remove A and B and just do C. You guys see why that's kind of a big deal? But it sounds like, it's like impossible to hear. It sounds like the defense is saying they'll defer to whatever the Commonwealth wants to do there. Okay. So hopefully that makes sense now that you can see it in writing, since this is like impossibly difficult to hear. All right.
If you can get me a case by this afternoon,
I will never do so, Your Honor. We will. I don't have it.
I'm inclined to go with the model.
I mean, I never really agree with Bev very often, but I agree that I think they should go with the model here. I think it's important that the jury sees that number C, or letter C rather, is like the last option, and the first two being more severe, versus only giving them the chain of events description, if that makes sense.
I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
Yeah, I mean, see, that's exactly my point, though, right? Because I think it's pretty clear to everybody that the jury's not going to go with letters A or B. You see what I mean? Welcome, Needs some Z's.
That's really anyone who's, I understand, and I don't.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply. Maybe.
I wouldn't mind.
We wouldn't have an objection to that.
Maybe I'll do that. But let me see if I can find something. If I can find something that says I don't have to give those first 2 prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, we see what the court is proposing. If you,
I mean, I don't know why you have to say anything. Just read it. Like it, whatever.
If I alter it, it means I remove those 2. That's all.
But no, we just want.
Yeah, sure. My guess is that won't happen, but we can see.
This is overcomplicating.
All right. So, lesser included offenses. Did you want an OUI instruction? You were
We're asking for that.
Okay.
all right.
So this was the other big news of the day, right? The change from last year. The defense is asking for this OUI instruction. So an added lesser included option.
Right. I think that's it. Aside,
Is an interesting choice, right? And we'll talk about that as we get into what's going on with the jury.
from Mr. Alessi's motion regarding the exhibit. Right. Is there anything else that we're missing?
Just a couple of other issues. One is with regard to the Proctor text messages. We have a
Proctor.
redacted version now, which we'd like to submit to the court of the Commonwealth. You recall that we agreed essentially on a redaction subject to the court's ruling,
Okay.
but it wasn't in final form. We believe it's in final form now.
And you all agree that it's in final form?
Well, they haven't seen it.
Oh,
I'm going to give it to them now. Can I hand this to the court?
Sure. Thank you. All right. So
The only other issue, Your Honor, is we do have a
hold on 1 second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it. And I'd prefer not to have to deal with it. So,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced in evidence, Ron.
Dr. Wolf or Dr. Rentschler? All right. And this was allowed into evidence unobjected to. I thought we already had it. We didn't.
We have to redact it, so we
Okay.
redact it. It's not a problem.
Okay. And the Commonwealth has seen it? All right. So they'll have to see it. So Mr. Blally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then will the court allow more than an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth. Can I hand
Okay.
the copy to the court?
Sure. Is it the same as last year's, but now with a?
It's different.
Okay. Oh, I digested it, Mr. Alessi. Go ahead. I'll hear you.
I'm actually United.
Unetti. Jeez, I'm sorry.
I digested it.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial
Mhm.
regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser included and the number of elements
And it's just going to get more confusing because now we've added an OUI on there.
that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done.
Yeah, it's stupid. It's pointless. There's no reason for it to look like this. It's literally like trying to gaslight the jury. You know, it's one of those things. It's like with a child or something, right? Where it's like whichever word they see more of. If they see not guilty one time, they say guilty. It's like almost like trying to, what's the word that they use? Like subliminal messaging, like to the jury of like, you should find the defendant guilty. I mean, that's how I interpret it. Beyond, in addition to being confusing, in addition to being like, there's no reason for it to be that way. There's no reason. No harm comes from giving the not guilty and guilty option for each count. Like, I just don't, And the argument, if you're Judge Bev or you're the Commonwealth, is just going to be, well, this is just the way it's always been done. And I understand how the law works, right? I get it. But just because it's always been done that way doesn't mean that it should be done that way.
Is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
The analysis is over. If it's a not guilty verdict, they go into the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final.
So you guys, we talked about this at length last year. Massachusetts has some wackadoodle situations going on with this that's very unique. If you guys were here last year, we read Rule 27B at length. And one of the things, and we're going to hear it when she gives the instructions, is like they got these different counts, right? And it's 3 counts, but then count 2 has all those lesser included. The way that I'm paraphrasing here, right, is that that the jury is instructed is basically that they have to, and I'm going to say it how it was last year, right, that they have to go in order, and that they cannot move on to like they have to start with the lead charge, which would be count 1, and they cannot move on to the second one until they've come up with a verdict on the first one, and that they cannot. But in addition, importantly, the way she said this last year was that they cannot offer a verdict on any of the counts unless they've returned a verdict on all of them. That's how she phrased it last year. We covered this at length, and it infuriated me because what she was basically saying is unless you've got a verdict on each charge, you can't submit a verdict on just one of them, which was one of the major issues because as we've heard, the jury wanted to acquit her on counts 1 and 3 and only be hung on count 2, right? And because they were instructed that they could not do that from Judge Bev, they left them all blank. And that was one of the big issues from last time, right? With the double jeopardy and all that. And so that's literally what Mr. Lessie's talking about here. See, he says, then go on to the next until they finally reach the final. So back it up again here. And of course, with Rule 27B, that basically says is that if the jury, if there's multiple defendants or multiple counts, here the second one applies, right? And the jury says that they're hung, that the court may ask them on which charge, if there's more than one charge, right? To find out if it's all 3 or if it's just 1 or whatever. And then they can ask further questions, basically in the trial court's discretion. However, there's one part of that uses the word must. Like, if they do say that they are not hung on all of them or something like that, then the trial court must ask which count and if they've reached a verdict on the other count, something along those lines. I'm sure it will be brought up. And of course, Judge Bev did not follow any of that last year. And it also infuriated me and other people because she really was not following what that instruction says. I kept waiting for her to follow it and she never did.
Not guilty verdict, they go to the next lesser included offense. And again, same analysis applies. If it's not guilty, they then go to the next until they finally reach the final verdict, which the least, I should say, of the lesser included offenses is simple operating under the influence where they have an option for not guilty or guilty. We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least like 3 of the charges, including the main charge.
I mean, the thing is,
there's this issue of ego.
y'all, I mean, we've all watched trials before, most of us, right? Some of us more than others. It is never this complicated, honestly. This is the only time that you see things that are this complicated when it comes to the verdict slips and the jury instructions is when you're dealing with really complex civil cases where you've got like a suit and then a countersuit, and there's a lot of if-then type of languaging. For example, Kowalski v. J. Hatch. However, in essence, like, for example, taking that one as an example, while literally by definition, when you look at it, the instructions and the verdict slips and all that for that case were so much more complicated. Like, there's not even a comparison, right? the job of the attorneys and the judge working together is to simplify it for the jury, which they did. So even though it was like a far more complicated case in terms of how the jury had to render a verdict, they made it way simpler than this case is. This is just not necessary unless you're wanting it to be convoluted for a reason, right?
Or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth not requesting any lesser included, and I certainly understand that if the evidence supports that the defense requested that the court was given. Having said that, the verdict slip that was used in this matter last year, the Commonwealth submitted is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently while this case was going on, tried before Judge Law, in which he had similar issues. I believe used at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in action. I don't have a copy of it on me, but I can certainly get the court a copy of it. But that may be somewhat helpful with the court.
Okay, was that on murder case?
It was not, but it had to do with felony motive homicide.
Okay, I'll take a look at it. Mr. Turk.
I'll take a look at it.
Mr. Turk.
He does.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Law was an excellent.
Gives her way more politeness and respect than she deserves, in my opinion.
Judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why I was.
Okay.
Well, see, the thing is like not everyone in this room wants clarity for the jury, sadly.
And that's where I think we disagree. So I will we'll take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right. So Madam Clerk, you have a copy up there?
Buy it for you, Bunny.
The proposed, I think this is the only copy.
Okay. That's what I was wondering. Okay.
Do you need an extra copy?
Sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please.
So it looks like there's, I forget what comes up next here. There's some more argument. Basically, it looks like that's the bulk of what they spend in terms of actually on the jury inspection.
Just for ID.
It's L.
So, Ally.
I just one request circling back to the constitutional field instruction. So Commonwealth was withdrawing its request for the instruction.
Okay.
However, would be seeking to make some argument or reference to the arguments of the jury related to specific areas which we need judicial approval before we did. So the two areas that are sort of listed within that that we'd like to make some arguments to the jury regarding is the defendant's taking of the Lexus from one metal that came to the parent's residence indictment, and then certain
Oh, this is the consciousness of guilt. I remember they talked about this last year and it was dumb.
statements made in reference
Yeah, it was dumb then.
later for statements.
Okay.
In particular, would be the one where essentially she says it's a that came to her.
Okay.
The exact.
All right.
There you can see Breenan with his closing argument, probably. It just says inevitably over and over again. Don't worry.
Mr. Yannetti, do you want to weigh in on that?
Yes, we would object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of.
I remember this last year, and I can't remember if they were able to argue on this or not. I think they did last
To
year.
another residence that the police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police called, she said,
And I feel like they probably, I can't remember, you guys, but if they argue it this year, but they did argue it last year, and I would imagine they probably argued it this year.
just gone over. I don't see that as being any evidence of consciousness of guilt.
Okay. So I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
And just to be further clear, there may be other witnesses.
Yes. So I did want to ask you, though, Mr. Yannetti, I think it's an argument that can certainly be made by the Commonwealth regarding the video clips that your client gave during various interviews. I think consciousness of guilt is a
Freaking
permissible
video.
inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we.
Okay. Okay, I just wanted to give you the opportunity. Okay. All right, anything else?
The last thing
Anything else?
they should be doing, I'm glad they're like the fact that she's like, take my advice. Are you kidding me? I think they're more than capable of determining what's best for their client. This blows my mind. Look at this.
From some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it
Stop it. Stop it. Oh, I just want to throw up all over her stupid hairdo, guys.
as well?
No, we.
Okay. Okay, I just wanted to give you the opportunity.
Hi,
Okay.
Pam.
All right, anything else?
That's
Anything else, Ms. Tina?
That's a good question. Do they know they can ask questions? I don't know. I don't know if they know they can ask questions or not. I don't know. Does anyone in the chat know?
We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redaction.
that's great. Thank you. One less thing you all have to do today. Okay.
This is Mr. Lewis.
I know. All right, so let's make that, are we switching that new redacted version of the exhibit number? Do we know what it was before?
Yeah. I mean, it's a good
The
question
redaction,
because there have not been any questions so far, right? It's a good question. The question of do they know they can ask questions? Right. There haven't been any questions so far. And so if they don't know, that could be one reason, right?
on the Higgins messages, that's what you're saying you're fine with, right?
Oh, they were told, okay.
Proctor Communications, okay.
This is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just. 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay,
Does the court have a copy or do they need a Commonwealth?
no, I wrote on it. I need the Commonwealths.
This is a clean copy.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Ms. Giannetti, we need to keep record of the first one.
Okay, this is
What
not,
do you think?
whatever.
Yeah. Just NNN, it's not
Labelings here.
office. To the clerk's office looks at it.
Your Honor, if I might suggest, respecting the procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might suggest to Your Honor, to avoid a more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 and introduction into evidence of exhibits. The exhibits is taken care of. That's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally can state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, Commonwealth's position is ultimately for the court as far as whether or not it's appropriate instruction to give in the final charge. What Commonwealth will submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the final charge.
All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you.
Mr. Alessi?
Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88, encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination and challenging Dr. Wolf on several aspects. And this one was particularly apt, that the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis. And that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end, undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan. And Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Laboratory, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
Your Honor, I think the answer is no, but because I'm doing it from memory and I don't.
This is not an official transcript, right?
Exactly, Your Honor. So I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie.
Yes, Fender, this is from the charging conference. So today we're catching up on the charging conference, closing arguments, and then, there's a tiny little bit of stuff that happened today that we'll go over too.
There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. Our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident.
and then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been.
This whole thing is insane, right? And the other thing too is that part of this whole issue, in my opinion, is because Judge Bev got all pissy when they were talking, you know, about this exact issue. And she's like, well, if you're not even going to listen, da, da, da. And then that was it. Like, that was that temper tantrum. She threw a temper tantrum. And at that point, she was like, you know, fine, I've got this, right? But then she didn't read at all what she said she was going to read. Okay.
Incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury therefore should not.
Like an obstinate fucking 13-year-old, although I feel like that's an insult to 13-year-olds everywhere. So I don't know.
Not weigh and value his opinion.
That's exactly.
This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth.
Oh my God.
We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury. I'm no soothsayer or mind reader, but I looked at the jury and they look confused.
Wait, are you saying, wait, hold on, Alessi, he says he's no soothsayer or a mind reader. Are you saying, therefore, that you are, where is it? Here we go. Are you saying that you're
not Nostradamus, but I'm not Nostradamus, but I'm
I wonder if that's him kind of poking fun at Brian for that, probably.
When I looked over at them, but I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue. And I'm not.
I mean, it's how he can even say that she does anything in good faith. Sorry, it's just a better person than I, because I don't know that I could even utter those words to her, honestly. But that's just me.
Not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things.
Yeah, and things were handled appropriately. Yeah.
Stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error. To me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred. That's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there. Again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came out.
Fucking hell.
That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider this.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just thank you for raising that. 10 seconds for
My
that.
God.
I will.
The audacity that she has. Notably, this was not an issue that she had at the time when this was discussed. This was not anything that she raised prior. So she's got a new problem, right? Just in case, it's like, oh, just in case the defense brings this up again, I better have another reason for why I'm not reading even just the initial curative instruction, which wasn't good enough, but it was better than what she did. She's like, I better have another reason for not, like, fixing my own error, if you will. And so she came up with this, and she was just waiting for him to stop talking so that she could say, well, you didn't object. Dude,
and I made this point
I know.
the
it's
very
horrifying.
time that I made the argument last time. We were not shown
Sure they
We
do.
were not shown that Exhibit 88 in the encasement. It was
Oh.
behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally?
Very briefly.
Hey, Reed.
Keep your voice up, please.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth file conduct of counsel.
Oh.
During the heat of trial, during the heat of the extended exchange with the witness on the stand, things can happen. Mistakes can be recognized,
Acknowledged and accepted as a mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in. There have been many instances of similar type conduct that didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper. It was a situation that arose as far as whatever misstatement was made at the time, as far as whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury. And furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient, and it doesn't need to be accentuated or addressed further in the final charge.
Okay, so I'll consider it, Mr. Alessio.
Thank you, Your Honor.
All right, anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45.
So you know what's really funny? When I heard this, I thought to myself, you know, she's not going to be taking the bench until 9:05. But boy, was I wrong. She didn't take the bench until, what was it, guys? It was almost 9:30 or something. Now, I will point out, and we're going to see it, like, it's not that she came into the bench and then they went to sidebar. They did do that, but she did not take the bench because everyone's always waiting on her, and we'll watch it. And my recollection was it was at least 9:15, if not closer to 9:30, that she took the bench. And at that point, it's clear that she had not yet even seen there's some other things that are filed. There's some other issues, right? She literally had just got there. She comes rushing in. This whole bit, we're going to have the jury here at 8:45.
Ready to start. So things take a little while generally. That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal would be to hear arguments from both counsel and then take an early lunch break. I would ask the counsel.
And when she came in late like that, my first thought was, you know what she's going to do is tell them that now they have to shorten their closing arguments to make up the time.
Plan on just a half an hour lunch break.
Guys,
I'd like the point being, I want the jurors to start deliberating. I don't want to
so she was an hour late.
end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch.
See, and that's the thing. It's like that time either it's either she gives them the hour and 15 for closing, which is not long enough anyway, or it means, what does this mean? Oh, the jury doesn't get nearly as much time to start deliberating. Like, you've cost them an hour, right? After this whole fuss, she makes such a fuss about it. I really want them to start deliberating so that we're going to get here early and we're going to get on with the show and and then she's an hour late.
Lunch, you're free to stay in the building and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least hopefully there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not.
This is so infuriating, guys.
Let them start deliberating.
I know y'all know.
We have no objection to that. One request we have, judges, during the last trial, during deliberations, the court had asked us to be within 5 minutes of the courthouse. My office is about 10 minutes.
So this part, I think this is the end of it. This bit about he's 10 minutes away. Okay, fine. See counsel at 8:30. See counsel at 8:30. By the way, as far as this whole thing, Fender, I've heard what's the word I'm looking for? Apparently, there's some people who say that, like, okay, there's definitely no court on Thursday, but I've heard differing accounts on this, that there's some people who are saying that they still have court on Friday, and others say there's no court on Friday. And I don't know that we have a definitive answer on that. But when I'm saying people, I'm talking about people who are there, like who is it, Sue, and then whoever the other dude is. Anyway, people on Twitter, I guess, and I don't use Twitter, but it came up with other people talking about it. And so anyway, I'm not sure that ever got, I don't think we know for sure. But and the jury left by, it sounded like they wanted to go home, but that's given her languaging. So take that with a grain of salt. Okay, so that's what I thought. Neeson Z's is weighing in saying Thursday for sure, but there's still not confirmation about Friday yet. Okay, that's what I thought. So now we're gonna jump to Friday, so closing argument day. So she comes on the record way late, right? But then they go to sidebar for a long ass time. Why? Oh, sorry, I'm not sharing this to you guys. I'm an idiot. Sorry. Then they go to sidebar for a really long time. Why? Oh, because things that they should have done the day before, Judge Bev leaves. Remember when I was like, oh, they have all Thursday. Great. Well, this is exactly why they should have spent time, because now they're doing this. And this is on top of her being late. Now, the outside of the presence of the jury is not the attorney's fault, right? None of this is normal, people. None of this is normal. And when here she's going to go and say something about the sidebar. I swear to God. Thursday is Juneteenth, so it's a national holiday. Friday, I don't know. It looks like they will probably have court. Come on. Swear to God, her.
Hey. All persons have any business before the Honorable Beverly Kennedy, Justice of the Norfolk Superior Court, before the Commonwealth. Draw near, give your attendance, and shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors. Good morning. So I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on it.
And she doesn't, you guys, what about, can she not for once say it was her fault? I can't.
Trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday? So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments.
You guys remember her saying this last year? I remember this. So this is like her spiel. She said this last year and it annoyed me last year. It's like what this is it's completely irrelevant. This is just her wanting to talk about herself as that she's been a trial lawyer. I think she's trying to impress the jury. This has no relevance to anything and it's really dumb. But she said this exact same thing verbatim last year.
You know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence.
Who gives a shit at what you liked and didn't like, dude?
The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them.
Just
But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And
Why would the jurors think it's less important? But you're now giving them that idea.
I'll notice that you paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, the constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. Right, the burden of proof is
Weirdly, she doesn't freak out when a cell phone goes off.
on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty.
I wonder
And
if because the one from the O'Keefe family.
Because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing argument. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing argument.
Here we go. All right, guys.
There was no collision. There was no collision. There was no collision.
So when I heard this, I got goosebumps, and here's why. The full circle. The full circle. It's giving me goosebumps again. The full circle is beautiful in a poetic and artistic way. Like, it makes the artist and me happy. Like, I say artist as a musician, right? Like, the full circle of it all. Like, we've arrived. Here we are after 8 weeks, and it just brilliant. Absolutely brilliant. I just adore it.
There was no collision. There was no collision. There was no collision.
Brilliant.
I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides. Proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we
So I just love that he says romantic designs again. That was such a highlight from the opening.
discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well, he got no response. And then we see this.
So
That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
here's the thing. Last year, I think pretty much everybody felt like this was a reach to say that they're practice fighting and all that, right? And it felt like a reach. This year, I will just say, and this is one of the, this is probably the biggest criticism that I would have. And it's not just in the closing argument, because it was also brought up in the questioning, right? When they were examining witnesses. Because this time around, we had new footage that we didn't have last year. That being the footage which happens after this, which is far more compelling, right? When they're going to leave and Chris Albert is like holding Higgins back and there's the gesturing and whatnot. That is so much more compelling. And we didn't have that last year. And I don't understand why they're making this same type of argument with this footage. And the reason that it frustrates me is because it allows Brian to poke fun at it, basically, in his closing. And it's one of the only, I would say it's the most legitimate thing that he says, in my opinion, in his closing, because I agree. It is more than a reach to try to say that this is practice fighting or whatever, right? And I mean, I feel like literally every single person that comments on this case whether it's somebody on YouTube or an attorney or in the chat or whatever, I don't know of anybody who says, yeah, this is legitimate practice fighting and this is, so I'm like, gosh darn it. Why are we bringing this up again? Can't we just pretend we didn't make this argument this year, Hi, Kelly, welcome. I mean, come on now. They're obviously goofing around, in my opinion. And you think, again, just to reiterate, they didn't need it this year, right? Because they have the other footage that's just so much more compelling. It's very weird. I mean, come on now. It's like a bromance thing. That's what it's like maybe there's
Sparring, practicing,
no
fighting techniques.
No.
Where was Brian Higgins' mind?
Here's what one last little thing on this. If you're on the jury, like if I was on the jury, that would be one of maybe the only things that I can think of, at least in hindsight. And again, I'll point, if I have other things, I'll point them out. But in terms of from what I recall of these closing arguments this time around, that would be like one of the only things that I can remember right now that comes out of the defense closing that is like, when it's so strong, when every statement is so strong, right? And every part of the argument is so strong, you lose credibility, to me anyway, right? To a certain extent, right? It's like it almost taints the rest of it. And especially right at the very beginning, you know what I mean? Because the thing is this is right. Like the defense is like, truth is on our side, right? We're not going to hide the evidence. We're going to show you the evidence. And you're comparing yourselves to the Commonwealth, right? And it's like, good versus evil or whatever you want to call it, right? And you really want to make a stark contrast. We're reasonable, right? We're going to be reasonable. We're not going to hide things from you. And then it's like, this kind of mars that, if that makes sense. You know what I mean? Yeah, I don't know. Does that make sense at all? I just hate it's in a way, it almost spoils just what's the way to put it? It almost spoils just how, like, I don't want to say perfect because there's no such thing as perfect, but it just almost spoils the pure, what's the right way to put this? Honest account of the evidence that you hear from the rest of the argument that I can remember again at this point. This was a couple days ago. And like, I don't know. Does that make any sense? It's a shame to me. You like this point?
Practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away.
I love.
Watch closely, and this is what you're going to see.
Now
this is what Michael Proctor and his investigation completely ignored.
Completely different.
Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look.
And I do agree with what you said about how it shows how immature Higgins was about peeing on his turf because his manhood was bruised. Well, I do agree that that is a better interpretation of what we're seeing there. The thing is that's not the argument that he's making to the jury. The argument he's making is that they're sparring as in like practice fighting, right? It would have been a much better argument if he were to go this route and say, yeah, his manhood was bruised. The jury could infer that, but that's not the argument he's making. Now this I love. And it's also much easier to see it too. Like, this is so much more compelling. So you don't need the other one. I personally,
Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke.
you know, the 3 question marks is interesting too, right? Because that's got a different tone than 1 question mark. Let me know in the chat what you guys make of that.
Even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car out in the cold in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to John's, her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m.
Yeah, and I'm glad he mentioned that because it's been a while since the jury's heard about that, but that's a huge flaw for the Commonwealth.
She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert. Think about this. Not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial.
I mean, it's insanity, right? Like it's crazy. It's crazy. Like that's true. We know that's true, but it's still crazy to hear that out loud, even when we know that that's true. It's still hard to believe, isn't it, guys?
Listen again to Dr. Scorti-Bello's words. Question. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident. Did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scorti-Bello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scorti-Bello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Lee Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered.
Right.
ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone.
So who all here, like, okay, whenever they were testifying, like ARCA was testifying, there were a lot of questions, well, not a lot, there were questions about the diffusers, and I remember thinking, we didn't really hear about this last trial that I recall. And it was one of those things where I wasn't quite sure where it was going, but now it's very clear where it was going, right? That it was on purpose, so he could obviously argue it in closing that there's a reason for that. And it's something they would not have been able to testify to. But he did a great job of asking very pointed questions about those diffusers in a manner that the jury definitely heard, because I definitely heard it. Like, I noticed those questions, but I just wasn't quite sure the significance of it. So anyway, he ties that up really nicely here.
Folks understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rinchler, PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think
Now,
about this.
Real quick, I have to say, I appreciate that he says the word save because this is very Shakespearean.
And shattered. But as you know, John's arm was pristine, save those dog and claw bites. He did.
Save those dog and claw bites. I just hope the jury understands what he's saying, because that's not to say, again, parlance. That's not common parlance. It is very Shakespearean, and I love it.
Didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter...
You can't manipulate a broken bone, right? And the point being, since they couldn't manipulate it, is that maybe why the Commonwealth did not show the jury these x-rays, right? I think that's kind of what he's hinting at.
Out of the diffusers, that it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory. Why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that he could do the reconstruction, the actual testing. Think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty.
You quit.
That's what happens.
There it is.
That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shanon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shanon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision, immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shanon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shanon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shanon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them, because there was no collision. Just look at Mr. Whithen's data, Ian Whithen. John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whithen himself conceded that he has reasonable doubts about the accuracy of John's location data. Remember that question and answer on cross-examination by Mr. Lessie. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation. This is science, and it's irrefutable. It tells us that he was not laying outside in the cold. He was inside somewhere a little bit warmer. Ian Whithen told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours, never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not
Another great point.
outside. He was someplace warmer, like a basement or a garage. Dr. La Posada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth La Posada, Judson Welcher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. La Posada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them.
I love this.
These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting, not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. La Posada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan. Did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Squirty Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside. And one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away.
Love it.
And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course, this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering.
So that's one thing that could be causing it when we talk about why it's taking so long. The defense urged them to read all of those text messages, right? So that's just one example of if they took that to heart and they're doing as he suggested, they're reading all those texts, talking about them. Just one example in terms of reviewing all the evidence that, could be taking some time.
But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously, get this done. His friend then asks what Proctor's probably thinking at the time, quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass bitch. She's got a leaky balloon knot, leaks poo, 0 chance she skates. She's fucked.
Wow.
And up to this point, Michael Proctor had done 0 investigation, nothing, save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Butnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator every investigator is supposed to be objective, an objective fact finder, no bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life? The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case?
And the thing is like, I hope the jury understands how crazy that is. It's one of the things that Michael Easter would have talked about, certainly one of many things, just so that they could understand the gravity of that. So I hope they get it, since he wasn't allowed to testify.
Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single witness is who had access to that shirt and who had access to those taillight fragments. And the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up, she did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm, because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer smooth part of the housing. Not any shard. It was the outer smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males.
Speaking of bromance,
That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sally Port. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves is that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing, the Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash, didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper?
Great point.
Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We can all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, using location data on John's phone showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house, except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door at the garage? I was asking her about the front door, side door, and the garage door, and her answer was, oh, actually, there is a garage door.
Nice.
Right there. Investigators never opened that door. Let's
I'm
change
glad you brought that up because that was something that I don't know that I caught so much in her testimony. I mean, there was just so much there that was a nice way to bring that point back up here.
Scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Reed. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with him for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins, and Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history, a dog that is, quote, not good with strangers. Dr. Russell confirmed that John's pattern injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabe's. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was timestamped by Celebrite at 2:27 a.m. A Google search that read, Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia?
I bet the jury forgot about that Hoslong search because that feels like a million years ago.
That's just a fabrication. That's just a made up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
That's a great fucking point.
Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. Yeah. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story. That was a dramatic moment in court. It's an admission of perjury, and you don't see that very often in a courtroom.
Well, in this trial.
It tells you everything you need to know about the character and quality of the prosecution's case and their witnesses, lying and perjury and admitting to it. A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time. She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabes. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling them everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that. Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video. It's not on audio. It's not in a single police report It's not in a single EMT or EMS report. Nowhere. The fact is, Karen never said, I hit him. You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you, that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe. He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up. Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house, Brian Albert's window. Jennifer calls her sister at 6:07 with all this chaos going on. No answer. Jennifer calls her sister at 6:08 with all this chaos and bedlam going on. Still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family. Why is that?
It's great.
Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe. The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine.
Mm-hmm.
That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that?
Yeah.
Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret. Of course they were flirtatious. Of course they were romantic in nature. The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins. Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way. Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if the report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up.
The skulking.
Moving bags.
Y'all, I love that. The skulking.
Between cars. And of course, that late night mysterious phone call on his cell phone, a phone that you don't have and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time. Kelly Dever, another Boston cop, told you that. She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moment that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch. That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at trial. One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agents in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop. And all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What?
Yeah.
So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand. You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely as Dr. Welcher stands as a surrogate. Is that a righteous test, or is that a manipulation? Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining it about how that test was meaningless. It actually didn't mean anything.
Right.
Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's
Why the point was he even hired? It's just
clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight, if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory. The Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car. Of course they were trying to suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts that it's physically impossible. That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision.
So, it's interesting because the theme from opening for the Commonwealth, right? Science, the facts, and the data, right? That was their theme. I think that's blown out of the water. One thing that I think is so interesting is how the defense theme has remained the same, right? Like I said, at the beginning of the defense closing arguments, I love that they came full circle with there was no collision 3 times, right? Their theory and their theme has remained the same, but what will the Commonwealth do? We'll see here shortly. The other thing I was going to say is, what was I going to say? Oh, hang on, I'll think of it.
That silent witness, that science, that physics has become very pesky to the Commonwealth because there was no collision.
Well, and speaking of which, there it is again. There was no collision. I know what I was going to say. I wish the jury, I know they can't, but I wish the jury could learn that the Commonwealth had this whole rebuttal case that they were going to put on featuring Judd Welcher and that they changed their mind. I know they can't learn that, but dang it, I wish they could, right? Because that speaks volumes.
Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm.
Mm-hmm.
Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment. Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt, not just to the witness, but to you, and asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you. And that's false.
So this is extremely powerful because it's nearing the end of his close. And of course, who's going to speak immediately after him but Brian. And so he's now, after calling into question the credibility of all the Commonwealth's witnesses and all the Commonwealth's evidence, to just kind of, as he wraps it up here, call into question the credibility and the truthfulness of the Commonwealth itself, as in Hank Brian, right? Right before Brian's about to get up here and talk to the jury, is so smart, and especially to save this for that moment as he's nearing the end, because it's like you want that fresh in the jury's memory that they can't trust Brian right before Brian goes and tries to gaslight them, right?
The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence.
It's not their job to do
That's
that.
dangerous.
It's not their burden.
It's dangerous. I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that? It's desperation. They know what you now know. what their experts know. There was no collision. So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict.
Brilliant.
Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Read. The truth is, Karen Read is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car.
Nope.
They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was
By the way,
hit
he was quoting Rentschler there, that you can't prove what doesn't exist.
by a car to begin with. They failed to prove any intent on the part of Karen Read because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth. And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Read, not just because you can, because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Read of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins. Remember his texts. Something stinks.
And I will say that I love, as far as this goes, I love the part where he says, if you convict her of anything, the science, the physics, the data, they lose. I love that part. But as far as the second part, where he says, but tragically, Michael Proctor wins, I feel like for me, that would have resonated a lot more had they seen Michael Proctor. Let me know what you guys think. Did what the jury saw of Michael Proctor this trial, I know it's hard to set it aside because we all have seen other things, right? Like the first trial and everything else. But like, do y'all think the jury is with him on this? Like, do they have enough of an idea of Trooper Proctor? Like, because I feel like whatever opinion they have of him, however negative it is, it's still just the tip of the iceberg, right? I feel like there's just still so much they didn't get to learn. So I don't know. What do you guys think? I mean, I have to wonder, like, was this something that was sort of written with the expectation that either them or the Commonwealth would have called him as a witness? I don't know. I just feel like, sometimes you want to have the boogeyman where you can't put a face to the name. But I feel like with a situation like this, for me anyway, I feel like it would be more helpful to have a face to put to the name, like that you associate with being the evil person or whatever. You know what I mean? The bad guy. Because it's like when he says Michael Proctor, I feel like they get a big question mark in terms of visually. But let me know what you guys think.
Remember his text.
Yeah.
Something stinks. Yeah. the serious charges will be brought on the girl. She's fucked.
I agree.
Could you ever, ever say to yourself, this is justice?
Hi, Kenny.
The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers, but in truth. Let the community feel, through your verdict, that justice cannot be bent and that it will not be buried.
Here, I think he's choking up. I'm gonna put it on normal speed because I noticed this when I was listening to it when I was driving and the day that this happened. I think he's actually fighting back tears. Just really, I don't know that I've ever heard that. That I can recall anyway from a closing argument, like when it's like legitimate.
But in truth, let the community feel, through your verdict, that justice cannot be bent and that it will not be buried.
Yeah.
Find Karen Reed not guilty.
Wow.
Not guilty. Not guilty.
Now, here's why that is exceptionally powerful. Again, coming full circle. This is brilliant. Here's why. There was no collision. There was no collision. There was no collision. 3 times, right? This is brilliant because the not guilty 3 times comes full circle with the no collision, but also there's 3 counts. That is incredible, incredible planning on his part. And I mean, man, you have to wonder if he took that into account in terms of the 3 counts when he wrote his opening statements to do there was no collision 3 times so that he could then in close do the not guilty 3 times. Because again, it echoes back to the no collision, but it also not guilty 1 for each count. Brilliant.
Thank you.
He's definitely choked up. Okay, so now for Brian, we're going to put him on 1.5, and I have lots of thoughts about this. Prepare thyself to be gaslit. You guys have seen this. That's okay. Even if you have seen it. Even if you have seen it. Actually, for this first part, I'm going to put him on 1.25 reason.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's just.
So when I heard this much already from him, I was like, you've got to be kidding me. What the fuck? What? I felt completely sideswiped by this because I was like, what? There's some trials where the victim is a huge part of the trial. This has not been that trial, right? This has not been that trial. Like, this came out of left field to me. I was like, since when has he talked about John O'Keefe, like, or even asked, like, this is just, what? I mean, obviously, I understand why he's doing it, because he's trying to be gross and manipulative. But the thing is the jury, I would imagine, probably, maybe not all of the jurors, but at least some of the jurors must have felt completely sideswiped the same way I did. Like, wait, where is this coming from, right? Because it's like, this has not been the theme. And again, going back to opening statements, right? Remember how I was pointing out how with the defense, their theme was consistent? What was his theme from opening? How did he start his opening? The heroes. The first responders are the heroes. It was all about the first responders. It was not about John O'Keefe as a person as much as it was about Nuttall and whoever the fuck else, right? The heroes. So again, similar tactic in terms of like distracting from like the evidence and whatnot, right? But it's like, now we've just switched gears and like, why didn't you do, this would have been less weird if he had done this in opening. I don't know. This is just so bizarre to me.
Keefe
Same.
was 46 years old.
Same. It's already so icky. And he does not have the capacity, in my opinion, to like, there's like no human compassion that I can sense from him. So this just comes across as, to me, as completely like I don't know, like the way a psychopath, right? Like this is like, I was actually talking to Twiz on the phone last night and I was saying how this closing argument from him, not to try to diagnose anybody, but this closing argument from him made me think, dude, like, are we dealing with some, antisocial personality disorder here? Because it would be hard to talk about a victim like this, right? Any victim, when you're the prosecutor and you're fighting for justice, and it almost seems like it would be harder to not make this seem genuine, even if you're faking it to be genuine, versus the way he does it, which is like just feels really icky and cold, at least to me, and disingenuine, and he doesn't even fake it. Let me know what you guys think.
46 years old. He spent his life helping people.
Mm-hmm.
He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community.
Yeah.
Everything you've heard
you guys.
about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in.
I mean, and remember, the jury watched him berate every witness, even when they were polite, respectful, even Dr. Russell. I mean, this just...
John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else.
I mean, yeah.
You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world.
Okay. So first of all, that's misstating the testimony from his own expert. Isaac Wolf never said that he had a 33% chance of living.
But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed.
And again, beyond all the people who were in the house and walking through the yard, the thing that I hope the jury remembers is that literally Jen McCabe was on the phone with him and texting him right before this supposed collision would have occurred. And not only that, she knew he was there because it was like here, and she saw the vehicle. So if anyone should have done something, it should have been Jen McCabe, right?
And she made a decision. In her Lexus with the shattered taillight, debris failed all over the front yard, and John O'Keefe lying helpless like a child on the front yard.
Okay, this also bothered me. Helpless like a child. This is where my red flag, it really set off for me the antisocial personality disorder potentially, because this is a really weird comparison. It's as if he doesn't understand that the jury. Okay, how to explain this? You don't need to give a light. You don't need to give a simile or a metaphor here, right? It's like regular humans understand what helpless means. Regular humans understand knowing what happened to John O'Keefe with the head injury and that he was like laying there dead, basically, right? And like whether it was snow or not snow, cold or not cold, that head injury alone would have killed him. Like, you don't need this. This is just odd. This is like almost like a fundamental misunderstanding of how humans can relate to other humans' suffering. Does that make sense, guys? Like, this struck me as so weird. And of all things, to say like a child, this was one of the odder parts to me of, I mean, there's a lot in this closing argument that's problematic, but in terms of just being really odd and like, again, coming across almost like AI or a robot, like before it's learned anything type of deal, where it's like, I don't know what it means to be human, like that.
She made a choice. She didn't call 911.
She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die.
Now, as gross as it is, I will say that, like, I think that this was only one of the few things I can comment on from his closing that I thought was effective in terms of he's kind of copying, in my opinion, what Alan Jackson did, right? So Alan Jackson had the mantra, right? There was no collision. There was no collision. There was no collision. And there were other themes as well. But in terms of if you want a mantra that the jury can remember and take back to deliberation, you know, you're speaking to the jurors that are on your side, right? And that's what he's doing. And that's why he repeats it twice. And not only that, but this is echoing what we heard from the jurors last time. And so, again, while this is horrible in every way in terms of what happened here, and, you know, but in terms of strategy, this is one of the only things that I can think of from his closing I thought was actually done well.
She was drunk. She hit him, and she left him to die.
Right. And so, again, gaslighting, not true. However, if you've got jurors who are on your side, you're giving them a mantra to take back, and that's why he's repeating it, right?
She was drunk. She hit him, and she left him to die.
That's a great point.
Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking at McCarthy's with John. She was drinking at the Waterfall. Her blood was taken with samples of the retrograde analysis almost 2 to 3
the other
times.
thing that's really funny is we're going to hear in the jury instructions that when it comes to those charges for the drinking, literally in the jury instructions, it says that the Commonwealth doesn't have to prove that she was drunk. Drunk is not the actual standard, which is the funniest part. Like, he's using a word that's completely irrelevant as per the jury instructions.
Times the legal limit. She was drunk.
Okay, I'm going to bump him up because he's tough to listen to. Okay.
She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data.
The timeline doesn't change except for when you changed it, though. This blew my mind that he said this in front of the jury. The jury's, what? The timeline doesn't change? Are you kidding me?
Characterize, malign, twist. The timeline doesn't change. It is data.
The timeline doesn't change. Pardon you? Dude.
Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, counter coup. You heard all about it when the back of his head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you got to get help. You got to get help.
So now he's making the argument that John O'Keefe could have survived. Again, if you're on this jury, are you believing this from all of the testimony from every witness? Like, what?
And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
I mean,
She was
right?
drunk.
Again, hilarious considering the jury instructions literally say that drunk is not a measure of whether or not the Commonwealth has met the burden of proving any of those charges related to drinking and driving.
And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event.
Now, this is interesting. So we didn't get to hear any of this testimony, obviously. So now we're finally learning a little bit about what they testified to.
It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee his niece told you. When there was an argument, John would do what John does. He would walk away. She described to you one time to get away from the scene. He walked into his bedroom, but the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And
How?
maybe outward appearance, they got along. Maybe sometimes quietly they got along.
Like, that literally doesn't make any sense to me. How does that mirror what happened on the night that he died? Their last interaction at the Waterfall was not that. I don't understand that at all.
Behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keefe drinks a lot?
I mean, his own argument, which makes no sense. If I was going to try to correct it, he's saying that, like, according to the niece or whatever, right? And according to Breen and according to the niece, who we didn't get to hear, he's saying that, like, they would have a fight and John O'Keefe would, like, want some space and then she would be, like, wanting to continue talking about it, right? And, like, knocking on the door or whatever and that type of thing. Which is, like, wanting to reach a resolution maybe, right? Wanting to be with the person and not away from them. So that, in other words, if John's taking space, that makes her feel uncomfortable. She feels insecure, so she wants to be with him. Literally the opposite of killing somebody, right? Like, in other words, what he's describing in a way, if I was to try to characterize it, it's almost like needy or clingy based on his characterization. So the opposite, so running somebody over is the opposite of that, right? If you are seeking affirmation, you guys see what I mean?
And Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks, more shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober. And then at the Waterfall, a shot, a mixed drink. Now, it was brought up at the Waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Can we have slide one, please? At the Waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins, barely greeting each other. Reality sometimes is different than argument. This is a celebratory move. Celebratory move. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe.
And like I said, that's the only thing where I was like, gosh darn it, they gave him that. You know what I mean? Because, yeah, y'all have not heard me say that I agree with him as in Breenan very often, if not ever. At least maybe not since like the very first hearing or whatever. But I agree. I think he's making a point here because, yeah, that was just like we already talked about it. But that's why I'm like, gosh darn it, they served that up to him to poke fun at it. You know what I mean?
In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol.
He actually says it. That's hilarious. It's not just the jury instructions. He literally says the government doesn't have to prove that she was drunk. But according to how many times did he just argue she was drunk?
Her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that.
But you know that's now what he's going to do, right? Like literally, that's what he's going to do.
But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol takes probably about 5 or 6 or 4. The drinks that they reported at McCarthy's, just where I consumed most of the alcohol, was the weakest at the time. It tasted just like all soda water with blue lime.
Slide 3, please.
I would have gotten on the expressway. I would have gotten on the expressway at 12:15. And it was quiet, the roads were very quiet, you can see how it feels. And I was going, when I had to drinks, I drive, it was very extra slow. So I know my alerts aren't sharp as they should be. But I shouldn't be driving.
Do you think she drank when she got home? When they leave the Waterfall bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the Waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12 on, we virtually have a historian in the data that tells
Does he
us
think that there's literally only one straw on the planet? It has to be that straw.
exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box in Judd Welcher, Dr. Judd Welcher. Judd Welcher took that data from the black box and downloaded it.
Why does he say that name? Like, is he broken? Judd Welcher. Judd Welcher. Judd Welcher.
So you can see the movements and the triggering events. And then Shanon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV.
Oh,
but what he did is he found a key critical piece of this case that did not exist before. He found a recent one. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make
missed it, literally, I missed it. I don't remember ever hearing about an SD card. What, is it just me? Do y'all? Literally, I'm like, what SD card? Is it just because I was so distracted by like his CV and all that? I don't remember anything about an SD card. You guys?
make fun of him, Shanon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable
I don't remember ever them talking about an SD card.
timeline that can't be broken. That's what Shanon Burgess did. And so we know on the way from the Waterfall to 34 Fairview, Ms. Mead is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said at the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiffen would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship. And then there's a trigger. There is a trigger on the way because they're lost. And when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next. Slide 4, please.
This is so ridiculous, you guys. I hate this so much.
Very close to the Alberts. In fact, when Jen was navigating John to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John pulled up prior to John and I dating.
And so they travel to 34 Fairview under the duress of this crumbling relationship, fueled by intoxication. We have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that to please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is an elevation. And he breaks down the data, the red, the green, if you can move down to the and then the bottom left, that's 34 Fairview. You can see second by second the circles of their route in the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar
And
Crest.
what about what the defense pointed out, right? Where the temperature drops and then it stays the same for like 5 hours?
And because of Shanon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. It's a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shanon Burgess says 21 to 29 seconds. Mr. Disorder comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made decisions like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We have all the arguments we want. They're there. They're together. The data matches up perfectly. Perfectly.
What? It doesn't match up perfectly even after you change the timeline. What is happening?
And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole. We know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest.
I want to know how he's going to explain the 1236 Wi-Fi connection, or if he, because I don't remember if he does or not. Let's see. But that's a huge, to me, that's a huge problem for them that they never addressed so far.
Or goes down to the right. They meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life.
I thought you just said that he could have still lived. What about the 33% chance that doesn't exist that you said happened? If just one person had called 911, what about all that? I swear.
In that car. He's in that car for most of it. Because Ms. Mason and Ms. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to.
The data
is
data.
And they sit at that flagpole for minutes. It's
So it sounds to me like the opening, it was the facts, the science, the data. He's now had to tweak it because of all the problems. So now it's just the data is the data. He's taken away facts and science so far from his theme.
24:33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nicholson, they're there about 5 minutes and then they go. It's not exact, but about 5 minutes they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down. She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car. And we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside or on the other side.
No, we don't know that. That dome light coming on was suggested to Brother Nagel by Brian. He was not clear on that I recall.
Is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves in 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly where John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved. Bullet. Come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes.
God, it's just hard to listen to him, you know?
Straight line, and he walks over to the door. In fact, could he even get to the door from 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy that somehow he walked in the garage, even though there's no evidence, there's no witness, there's no data. 20 seconds of his life, and he moves. And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail in every little second. We don't have to. That's not
well, if you don't know anything.
Not reasonable doubt. We know for that 20 seconds he's moving, and in that 20-second window, when he moves, he has his phone. He looks down. 12:32:09. He sees a text message from his friend Gemma Cade, and he looks at the text message, and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. But like knocking on the door, like Kaylee said, getting the last word, she doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Canoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Ms. Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder.
What is wrong when people, what? Who thinks that that's the only way that people can be murdered is by shooting or stabbing? That's insane.
It's different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Ms. Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe.
Remember how we talked about the second-degree murder and we looked at A, B, and C? He's talking about the chain of events. That's letter C. So I would imagine, and I don't recall what ends up happening, I would imagine that they did get A and B taken off because that's how he's able to make this argument. Remember when I was like, I don't like that? So he's able to say second-degree murder basically only means the chain of events, but that's not, you know, that's not what the standard elements are, but it looks like they must have succeeded in having that tweaked.
She intended
It's
that
on
act.
high speed. Yeah, it's on 1.5 because I'm hoping to just get it over quickly, like ripping off a Band-Aid. We can slow it down though if you guys want, but it's painful to listen to.
The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and if that conduct will create a clear and plain likelihood of death, then she's guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy.
Please don't.
If somebody, maybe a teen or someone young, impulsive, is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody.
It's really funny, as you guys, I'm sure, are familiar. This is an actual case.
Throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge,
Which I feel like this is really bad form to give an example of an actual case that is existing and I think still pending trial. Like, ugh.
and it comes down and lands on the car, and there's somebody, passenger, anybody in that car, and it then goes through the roof and kills the person in the car. Did they intend to kill that person? No, they were trying to have a thrill throwing it off. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died.
This literally makes no sense, though. Like, whatever.
I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly? in a way that would very likely result in serious injury. When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is.
It's just hard to listen to. So as far as for any of you guys who are asking about the terminology, so that is explained in the jury instructions, but I've got copies of the jury instructions. So Judge Bev will read it to the jury, but we can also break it down as per the jury instructions and the verdict slips and everything. But yeah, the elements of each charge and then the different definitions and whatnot, we'll get into all that once the closing arguments are done.
Wanton. It is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two.
What he's basically saying is that anyone who drives backwards at a certain unknown speed should expect to hit a person and potentially kill them. That's basically what he's arguing. Which I don't think that's a very solid argument, personally.
3 is leaving the scene, knowingly, causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she comes to 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with him. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever the disorder wants, he stops moving. John O'Keefe stops moving. Forever. Forever. That's slide 6, please. You'll get to see this more closely. You can't probably see it where you're sitting, but there's important data. Data doesn't lie. You will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast.
If it's not necessary, then why are you arguing it?
That reckless.
Also, we just talked about somebody coming hard and fast, so let's just take a moment to.
That obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed. Can't be attacked. ARCA, they did some crash test dummies. You know what else they do? Tech stream data. There's nothing about that data that is uncertain. Nothing. Take that down, please. When Ms. Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back, but we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head.
The logic is so flawed here. And, I love that Dr. Rentschler completely tore that apart. He said, the fact that there's taillight on the yard doesn't mean there's a collision if the body shows you there was no collision, right? Because there's other ways to explain the taillight getting there, right? And actually, Jackson argued the same. He said the same thing in his closing, right? You could explain away. There's other ways to make the taillight happen, right? But you can't, like when he showed the X-ray of the arm, right? He was like, you can't pretend there's bruises on the arm or fake bruises on the arm or however he phrased it. In other words, they can't falsify or fabricate the injuries to John O'Keefe, right? So if you're going to alter one thing, what can you have more influence over, after the fact?
His basal fracture. He's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard.
Yeah.
All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact.
False. It's called the debris field. Get it right, Brian.
Contact. You can't because you need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, she's still angry. She's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12:31:56. 12:32:04 to 12:32:12 is the data, which is adjusted when you reconcile the box and the Lexus. 12:32:09 is when so he closes his phone after looking at Jen McCabe's text. 12:32:16.
Wait, isn't that the court TV graphic that they made? I mean, it looks like it.
Is his last steps.
They steal that from court
The
TV.
story says that red range can move a little bit 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't
That'd be
matter.
wild.
It's all in the same window. It doesn't change. We could have slide 10, please. Can you play that, please? Okay. Each one of those pegs. You can't play car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly laid on the ground, abandoned, you're gonna have to ask yourself a question for charge number 3, leaving scene, knowing somebody was injured and then died. You're gonna have to ask yourself, is there evidence that Ms. Reed knew that she'd hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the 3rd charge, Commonwealth has to prove beyond reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. We have slide 8, please.
Could I hit him? Did I hit him? I don't know what could have been. It was howling wind. I had YouTube blasting on stereo. And I thought, did he somehow try to flag me down, which was a reaction? I was hoping to garner as I slowly pulled away from the house. Did he come up and maybe trip or bend over to pick up his cell phone and I bent over his foot and he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
When she left Fairview and left John behind, she didn't think he was mortally wounded. She knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voice no one, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone data gets compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whippin's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe was in the house, absurd. 66 turns to 61, it's 12:53.
A Samsung
48 unanswered calls from the defendant. He's not in a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, the cell phone would be moving. There'd be healthcare data. There'd be steps. If he got into the house in 20 seconds and the cell phone is found under his body the next day, and how would he get back outside? There would be more steps because his phone is working. The data is the data. There's nothing wrong with
This
it.
is so stupid because all it would take is for him to drop his phone in the yard and then go inside and whatever the fuck else could happen. And the phone could stay in the yard and then he could be brought back out and put on top of the phone. Like, it's not that hard, Breenan. He's asking questions. And I mean, I don't think this is a good strategy because literally it's not hard to come up with really simple explanations for his questions that fit with the evidence. Like, you don't want to be asking questions to the jury like this.
It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voice note number 2, please. Listen to this.
John, I'm here with a fucking kid. Nobody knows what the fuck you want, fucking murder.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records.
It's like the royal we, though, obviously.
And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her.
Oh, for
Except her.
fuck's sake.
Why is she asking? Nobody knows who you are. She is starting to get panicked because she knows she hit him. Not suggesting she meant to kill him or for him to die, but she knows she hit him, and now he's not responding, and she's getting nervous, and she's getting anxious, and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. Take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?" She doesn't call Brian Higgins. Has his number, has been texting with him. "Hey, was John in a party with you? Did you see John tonight?" She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand where she's saying, "Call Jen McCabe, call Jen McCabe." Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? When did he leave the house? What happened last night? No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See, now it's gone from panicked to self-preservation. "I left him at the waterfall." And Jen says,
So
"Left him at the
grotesque.
waterfall. I saw you in front of the house." Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see, but someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, "Carrie, Carrie, Carrie. John's dead. I think he got hit by a plow." Why do you think she chose those words? Why did she choose those words? Because she knew that there was a
Because maybe she was thinking Higgins was involved. That's what I would think. If indeed she said that, potentially what that would mean to me is her first thought was that Higgins was involved.
collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus.
Are you joking? Is he just going to completely leave out the fact that Higgins was driving a Jeep with a plow on it? You've got to be kidding.
Another big vehicle. I think he got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that.
Great question. Did she really say she left John at the waterfall? The only evidence we have of that, if you can call it evidence, it's testimony from Jen McCabe. Unless Karen says it in one of her clips, but I don't recall her saying it. But nonetheless, even like last year, for example, before the clips even were a thing, Jen McCabe said that. But I think that's actually really good evidence for the defense, personally.
But what's going to happen, what they're going to see, what they'll never be able to forget.
Because again, it was Jen McCabe who first suggests that she came to the house with him. It was all that suggestion. It was all a matter of suggestion from Jen McCabe, because Karen's first thing was like, I left him at the waterfall. And then Jen was like, no, you didn't. You took him here.
The defendant is John O'Keefe's girlfriend. They wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom was a perfectly normal life.
Soccer mom
gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays.
Oh my God!
To put herself in that position because someone asked for help, because that's what good people
calling her kind. Wow.
will do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts separately at that time answers the call, gets out of bed, drives to go help because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judge Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing. No taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken because when you look at the video, not one little piece, it's still framed, little angle with the light breaks. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing because it's back in Fairview.
Well,
it's missing. It's not there. It's back in
We
Fairview.
did it. We watched that on slow mo a bazillion times, and it does not support anything that he's saying.
And then she leaves at 5:07. She gets to Jen McCabe's about 5:35, 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going up to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because
Can't
John went out and tried to
understand
drink,
her.
fell asleep
I
on
mean,
the couch.
that misstates the testimony because Jen, according to Jen, said that Karen said it was really easy because it was just one word over and over again. Jen, Jen, Jen. So where does the can't understand her come from?
Because Dawn would maybe be cheating on her. What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death?
Oh, wow.
Carrie Roberts
That was a hell of a suggestion to make that assumes a lot of facts that are not in evidence. Wow.
take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going to the back meadows. You're going to follow me. Leave the car. I'll drive. At this point, Jen and Carrie don't know each other. They only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Carrie Roberts, Jen McCabe. They're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness. They can't see anything. And they're driving and driving, and they decide to go back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find him because she knows where she left him. She tells us. Slide 13, please.
I mean, according to him, though, she didn't know, but she had to go drive ahead of time and go and take a sneak peek or something, which none of this makes any sense. So I don't know why.
This in the passenger seat. And I described this to everyone, so you probably know this before, but John lived a buffalo on the prairie. It was just a lawn in a heap that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe. A weird shaped lump, not like a bush, and that is John O'Keefe. She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene.
Yeah, you are.
Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. Guess what happens when they first move him around 603, 604? Ian with him, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved.
Ian Whiffen, who said that he has reasonable doubts about the cell data in this case.
That 22nd hasn't moved. They start shaking him. You're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. She plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert house. The glass, well, you will hear in the clips. If we don't play it, you'll have all the clips with you. She talks about the fact that he took her glass. He took the glass. She says it. So the Albert house, they don't need to get glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact.
For fuck's sake.
The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw.
Wouldn't you also think, though, that using a snow plow on the street, plowing the snow would also take a straw, would get swept up in that and get shuttled along down towards the end of the road or whatever? You know what I mean? Like, anyway.
Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a cell-bright record is not the same as a call detail record. There's no evidence, there was a conversation, no lights go on, there's no conspiracy. You can call somebody, it can ring, it can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was whipped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend.
And a shoe.
Prone.
Yep.
Lifeless.
Right. Yeah, I mean, we know, we've seen those blades, right? They go right on the road. That's the whole point. So, like, when they're plowing the road, I mean, this didn't occur to me until now, but like when they're plowing the road, not just snow gets pushed along, right? It's like anything that's in the road, right? Debris is going to get swept right along, pushed right along. You know what I mean?
Frozen on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there's not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time has anybody said, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Can we have
What are you even talking about? Law enforcement didn't measure. Oh my God.
slide 14, please? You can see there's Kerry Roberts' vehicle, and then on the left, you can see where they were. Right off the road. That's not going to be. That is a clip. They stumble and fall. Remember when Doug fell, there wasn't snow. It was just the beginning of dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? It causes this type of injury all the time. All the time. If we could go to slide 16, remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then Exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass.
I wonder what he's going to say, though, about the glass on the bumper.
That was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night.
He carried the glass with him. Now, this is back to Trooper Paul theory, right? Carried the glass with him after that? After he was struck? You guys.
Remember the straw? I asked you to take a look at that picture. We're leaving the waterfall at 1212, but black
This is
straw
craziness.
on the street.
And like there, and like literally what I was just saying. The straw is like in the middle of the fucking road. And you can see that the road is bare because it's been plowed. Makes no sense.
Collision, glass, nose, straw, back, hits his head. You play.
Is that like Greenan reading from like one of those learn to read books for 3-year-olds? Listen to this.
Right on the street. Collision, glass, nose, straw, back, hits his head.
It's like that thing, what was it? Like TV, man, window, whatever that test was that Trump had to do back in the day. You know, you man, woman, whatever it is. Anyway, it just reminds me of that. You know, the dimension.
You play the clip on the left, please. 59.
So when John got out of the car at Brian Albert's house, he took my full bottle of soda, which is sitting in the cup holder.
169, please.
So John's laying there, left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it. And as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics. They've been getting to work 2 hours early for the blizzard so they get there on time so you can help people. These are the core of our community.
Well, as dumb as I think it is with this whole thing about the heroes, and it's just totally like a red herring, I guess at least he's circling back to his theme from the opening, because that's something that's good to do. Not when it's something that's like dumb to begin with, but like at least he's circling back to that. I guess.
At all. This is what he does. He rushes
Here
to
we
go
are,
help.
back to
He's the
zero.
first person on his knees. He doesn't know this person from anybody. But to him, it's another human being. This is his passion. Katie McLaughlin, first responder. This is not just a profession, it's her life. Yes, she knows Caitlin Albert. You think she went there that night at a party and set up a murder and came back?
It's her life.
And so they tell you what happens at the scene.
Hmm.
Some things, hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nettle remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit
Except
him.
for all the
I
times his testimony changed, dude.
hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with this, so she has to bring people with her to face it. And now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him? Could I hit him? Perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece of that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent core people who hear her say, I hit him. I hit him. And the attempt is to betray everybody. It's a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
You have a guide? What is it talking
So
about?
what's
Guide?
this? Did I always said I did, but did I really say this many times as law enforcement is cleaning? I said it.
Okay. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself. She hit him. It's undeniable. It's unmistakable. It's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is
Seeping up? I mean, this just goes to show you his notion of truth is seeping up. Like when I think of seeping up, that to me sounds like sewage, right? I mean, but I think that that's like what's the word? Like a Freudian slip or what, if you will. You know what I mean? Like he can't have he doesn't have a concept of the truth. So like, what's the word I'm looking for? You know, like that's him saying what he really is thinking. I'm sorry, the words at the tip of my tongue. When he says the truth is seeping up, it's like not, I mean, similar to a Freudian slip, but that's not exactly what I'm thinking of. Anyway, I don't know. I can't remember the word I'm looking for.
It's not a coincidence. There's no coincidence that Mr. Nuttall and Ms. McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Ms. McLaughlin, she tells you she saw her the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, ironic thing is, you will see in a photo when Ms. McLaughlin, firefighter, was speaking to the defendant, Ms. McCabe was next to her. Ms. McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of the story was trying to help the defendant from incriminating herself.
Villain?
The irony. Can we have slide 9, please?
The villain?
This is the bad.
Proctor the villain?
You're going to have a chance to look at it. And it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they'll leave the waterfall, 82 degrees, 1222, in the car, 77 degrees, 1237. About 3.5 minutes after the defendant collides with John O'Keefe, it started to go down 72, 1245, 66, 1253, 61, and you see it drop and steady off at 136. Remember, cell phone battery under him, John O'Keefe either struggling for life or he's passed, and the blood's still warm either way under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Carrie Roberts goes over, takes up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next meeting, the temperature rises. That's not convenient. That's not coincidence. That's fact. That's data. And then the phone is passed with a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress,
right,
the defendant asked Jen McCabe for yet another favor.
Right.
Look up hypothermia. Find out how long it takes for someone to die in a cold.
Right. So Annie's making the point that he's focusing a lot on Jen McCabe being the villain when she was not the villain of this trial. She was the villain of last trial, but this trial, it was definitely Proctor.
McCabe in her winter jacket, soccer mom, trying to help. She has MS. Her hands aren't working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again at 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her.
I mean, if anything, by doing this, he's drawing more attention to Jen McCabe being sus because really the defense didn't focus on her really at all. And she was mentioned like one time in closing, but like they totally did not make Jen the theme of this. And he's talking a lot about Jen.
And what happens to her after? Because the timestamp, when you open the timestamp, It's at the time it's open, and she's in bed at 2:27 looking up Hawkmark Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that's being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help.
Murderer?
It took Ian Whiffen
A
5 minutes.
murderer? Who called her a murderer? Well, Brian did. Literally, Brian has now put that suggestion in the minds of the jury. What the hell?
And
Brian,
that's being portrayed.
wrong. This is an own goal, Brian. This is what you call an own goal.
That she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help.
Wow.
It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You user can't delete that information. That's not a click and swipe like the good Dr. Wolf Marker knows how to do. This can't be erased.
Ew.
But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27. Look the other way. Don't look at what she did.
You know, guys, remember from last year? That was the theme of the defense close from last year. He copied that. He copied that from AJ last year. Holy shit, dude.
Former Trooper Proctor. Look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Albert. Maybe in the basement. Look the other way. Go the other way. Look at the facts. Look at the data.
You guys
Look at all
remember because Jackson's theme was "Don't look the other way," and I remember very much like he had that line that was really powerful last year, and it was like, "I see the truth, and I will not look the other way." Wow.
It's to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself.
Whoa, guys, StreamYard just freaked out. Like I said, people have been having issues with it. StreamYard just like completely glitched out. So yeah, like, wow, that was odd. Okay, let me put this back on the screen. That was very odd. It just like completely glitched out. You know what? I think it's had enough of Brennan. Hi, Doug. Welcome. No verdict yet.
Invoked with this emotion early in the opening that this is a cancer. That's a tough word.
Okay, so now he's talking about emotion.
Or invoked with this emotion early in the opening that this is a cancer. That's a tough word. Trying to evoke that primal reaction disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. They're not defensible. I don't stand here and defend impropriety. I don't.
I will say I did have when during the opening statements when Jackson said that Michael Proctor called him a cancer. I will say that I had a reaction to that. And here's what I'm going to say is that I lost my dad to cancer in 2014. And for anyone who has there's definitely at least one person on the jury who's lost a loved one to cancer. For anyone who has lost a loved one to cancer, that word hits, well, in my own personal experience, that word it hits differently. Like everybody hates that word, right? But when you've lost somebody to cancer, that word is like, it just has like, it has a different effect. It's almost like I don't know if PTSD is the right word, but anyway. And I remember thinking at the time during opening statements of AJ, I remember thinking that's a bit risky because depending on who's on that jury, that could make somebody and I'm not saying it would make them hate Jackson or anything like that, but it very easily, you could see how it could be distracting, right? Like if somebody's really listening to your opening statement and then they hear that word cancer, and let's say they've lost a loved one recently to cancer, or even not recently, it could totally pull them out of listening to the opening statement because now they're in a different place, subconsciously, right? Unintentionally. And I remember thinking, I don't know that I would have used that word, but, I just was like, I understand why he used it, but at the same time, that word has a very specific, way to jar people in a very specific way, if that makes sense. So, but hopefully that didn't happen. I just kept thinking like, that would be a shame if he lost some people on the jury, even if they just started again thinking about their loved one. Totally fair. But you want them listening to what you're saying. So anyway. Right. And that too. That as well. Yeah. That as well. Yeah. Again, like best case scenario, potentially maybe it was just could be distracting to some, right? But again, worst case scenario, what you don't want is to offend anyone on the jury, right? And you could see that being a possibility as well. So yeah. Oh, that's interesting. EDB's live went down for 45 minutes. Yeah. Well, at least it was quick for us. So.
But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper Lieutenant was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But it does not change, doesn't create a conspiracy, doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the
Why does he think that helps?
disdain one might have for his comments. Not that those evidence.
Like literally, he's basically may as well be saying, well, I didn't put those in because I figured Trooper Proctor planted them, right? Like, I'm confused.
Tampering. Not that there's any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Mechanic and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing.
This feels to me like an admission that he thinks the taillight was planted. What about you guys?
The driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it. The dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene.
Objection, facts on evidence. How do you know Trooper Proctor's in his pajamas? That did not come into trial this year or last year, for that matter. He's in his pajamas? What is he eating, pancakes? What the fuck is
missing? It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He's been near the car. And then the Dighton videos themselves, when you close, you take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please?
Word.
507. Play anything you want. If you look at this angle, it's gone. You don't plan it. It's already gone. You know where it is? 34 Fairview Road, on the refill. January 29th, 2022, Waterfall House, 823. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing, when we do the videos, it's a different angle, a little smaller. Play that and watch the lights go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad, or couldn't have been it, you got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case. A lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in the conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he says,
I did not see the redness creep over his face. That's really gross to be, dude.
on the stand with a new story after a meeting. We don't know why. But then I show him that black and white photo with the snow, with it missing. And I say, is this the way it looked? That's, of course, before the snow melts out of the salad board so that you can see it unexploded. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad board. There's no one tearing out pieces. In fact, remember I played
Didn't he just call Proctor the boogeyman like 5 minutes ago, though?
clip, you'll have it where the defendant says, I was picking up pieces, it was crashed in, the bubble showing, when I showed Mary and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves. There's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert.
According,
Thing is, we know no
according to her, she's a nice woman. She didn't say that about herself, dude.
idea what that expertise means. She volunteers for the job. She wants to be here. It's on her profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth,
That's not true.
and then it's claws, then it's teeth, and then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. Laposada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. Oh, is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now
He doesn't know
the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box.
But it didn't change. He's like, oh, she only had the case for 90 days. But then he says, hold on.
The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing
Yeah, but her opinion hasn't changed, though.
about the black box, nothing about the interviews of Miss B.
And, look, to try to suggest that a forensic pathologist looks at cell phone data is the most ridiculous fucking thing I've ever heard in my life.
She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Just write that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower body injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she in 90 days saw a fraction of the information, a fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion.
Then what's the point of having a medical examiner then, Brian? If you're like, look, 90 days isn't good enough, you're only going to see a fraction, then why are we having them rule on cause and manner of death then? What is the point? Can we trust any cause and manner of death ever done in the history of time then? Complete chaos would result. This is insanity, guys.
Is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car, have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries.
No one said no injuries.
That you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there's no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them.
Wow.
What expert who's supposed to come to you? They're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We heard words like confirmation bias, objectivity. Mr. Wolf got on the stand. And before we even started, you have to ask yourself, what expert has a court order for text messages?
Oh, God.
And then deletes the text messages. What expert?
So this was completely objectionable because that's misstating the testimonies, the facts on. This is not correct. But the defense is clearly relying on the jury to remember that this is not correct because that's not what happened. The court order was after the text messages, long after the text messages were gone.
What objective expert uses Signal, an encrypted app, to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than Don O'Keefe's metric, which would be 11.8. That's all. And because the lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to?
I will say it was clear that during the course of this trial, he doesn't know science or math very well. That's clear.
Help you? Because Dr. Retrial came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. So you adjusted. And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got to his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her little ride over? If Brendan asked you
Your
a
little
question,
ride over?
make sure you ask for the transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens to Dr. Retrial, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from the former employer. He said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal. Just ask him
I feel like his closing argument is way longer.
about it. And he says, I have a sandwich and I stand in the corner until I remind him.
Oh my
that we
God, and the ham sandwich. Really? He's bringing up the ham sandwich again?
got video footage
Oh my
from the
God.
documentarian.
Oh my
using one of
God.
the scenes. And then things change. So when you talk about objectivity, if we try, they can come in and say, Judge Welcher said this and that, it doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. They were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk.
It just makes no sense.
She hit him. She left him to die. It's that simple.
Where does that same mantra he's repeating?
We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can.
Oh, Lord.
We don't know if this is the body position. We don't know if this is the exact speed, but it tells us this is viable. Look at the refill. Look at his turn. Remember his
It's viable.
sneaker on that curve that got lodged against the sneaker. Mr. O'Keefe
I mean, to me, it looks like he would have lower body injuries, though.
then falls back, hits his head.
His foot just got ran the fuck over.
Left to die. Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him.
In that anger, at the beginning of this whole thing, he said that anger is not an element. They don't have to prove anger, and she doesn't need to be angry. And he followed that with trying to suggest she was angry. And now he's, again, suggesting the anger thing as if that's a part of it. That's just playing off of emotions. It's really disgusting. But also, it's just contradicting himself.
She hit him. Straight. It is a plain and strong likelihood of death. You would never get back down your driveway because of the end of the driveway. You'd say, we could kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not it.
This is really offensive to me because Brennan does not care about this person at all.
John O'Keefe is not a body. John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
Never once thanked the jury for their service. There's a lot he didn't do, but that's like a cardinal sin. Wow. He was a buffalo on a prairie, and he was murdered by Karen Reed. He didn't even say that you should find her guilty of name any of the counts. He didn't even say you should find her guilty of second-degree murder. He didn't thank the jury. Anyway, what a mess.
Take it, thank you. All right, juries,
The next up is my instructions to you on the law. I'm not going to do that right now. You've been sitting.
Okay, so they go to lunch. Let me see if they put anything on the record. Sidebar. I don't know if they come. Okay, that's off the record. So they go to lunch. They come back. So now we're going to get to the jury instructions. And
some space here, please.
what I'm probably going to do is skip the preliminary because those are not the most interesting, and try to get to the ones that are more specific as to the elements of the charges. So let me just go ahead a little bit here. I'll put it on 1.25, and then we're gonna watch the few seconds of what happened in court today, and then we'll take a look also at the verdicts.
Or transmitted or created the communications were the persons alleged.
Again, these are all basic, whatever, standard. Okay.
In mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you.
So Brian could do well to listen to these and try to learn what a reasonable inference is, because clearly he does not know.
Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition.
So what that's saying, right, is if there's two equally plausible, right, reasons for something or whatever, two equally plausible scenarios, you have to go with whichever one favors the defense. That's what that's saying.
In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail.
If that person telling me that was Brian, I would be like, nope, that's not what happened. The U.S. Postal Service did not deliver the mail.
The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible.
Yes.
On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify.
Did y'all see her marking? It's because there's typos or misspellings or whatever, and she's correcting it. For anyone who's like, why are you mentioning that? Well, if you go back to the beginning of the stream, I had plenty of rants about how she conducts her charging conference, and that will make it very clear as to why I ranted about it and why I'm now ranting again about it.
She is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions.
Okay, now for the exciting part.
Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm.
Okay, so that answers my question about this. They did not remove A and B from this. They kept A and B in addition to C.
To John O'Keefe, or intended to do an act which, in the circumstances
So
known
here, everything's going to be defined and laid out for these elements, guys.
to Ms. Reed,
And don't worry, we'll break it down.
a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to.
So here's the thing. I guarantee you this is all from count 2 still, right? I guarantee you this is part of what is, well, if the jury is having issues, not that they're having issues, just saying, they might still just be reviewing the evidence, right? But if they're looking through count 2 and going through count 2, that means that a couple things. That means that, first of all, they've already decided on count 1, likely not guilty, but remember, she's going to be telling them they have to go in order, right? But when they get to these, listen to how it's being worded. So what you will notice is that in count 2, there's noticeably absent from it is like intent. Also noticeably absent is collision, right? The thing about count 2 with all these lesser included, which she hasn't even gotten to yet, is it's really more about drunk driving. And so essentially what she's already outlining here is the elements that the jury is having to consider is basically, does she count as being under the influence? That's the question that they would be wrestling with first. Was she under the influence, right? And as you can tell, it makes it really complicated to even determine that part. But basically, it's a matter of with these different count 2 and the lesser included is like, was she under the influence? Was she driving? Well, we know she was driving, right? And did she operate a motor vehicle? And then there's a number of different standards depending on which lesser included you're looking at, because we've got the wantonly and recklessly, but then there's also going to be the negligently one. And then of course there's an additional one that we didn't have last year, which is the OUI, which will be the last of the lesser included on count 2. So as we listen to this, just think about how this really, in my opinion, really has no place here, right? Like a lot of this is really more akin to your standard DWI or DUI charges that are like not a part of murder trials typically. And with good reason, because it kind of seems like, what's the right word? Conflating, if you will, completely different alleged acts of a defendant. So, okay, let me back it up a second. So now with that context, so you guys can listen for these specific elements here.
Or greater. I will now instruct you on both theories.
It happened last year.
What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol.
So here's the thing. Did you guys hear that? The Commonwealth does not have to prove that the defendant was driving in an unsafe manner. They don't have to prove that she was driving in an unsafe manner. Just simply that their ability, the defendant's ability to drive safely was diminished by alcohol. Now, here's the problem. Think back to all those Karen Reed clips, right? Karen Reed, in her own words, said in one of those clips, I shouldn't have been driving. My faculties were impaired, something along those lines, right? She was like, what did she say? I wasn't as sharp as I normally would be, or something like that. You guys see why that's a problem? And again, we're going in order. This is just as it pertains to the ability to drive safely and whether or not she was under the influence of alcohol. You have to go one at a time. And right now, before the jury is getting to anything else, because they have to go in order, right now, if they're on count 2, this is where they're starting with. Was she under the influence? And as you can see, these jury instructions totally favor the Commonwealth in saying that they don't have to prove all these things, right?
Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required.
I find that pretty shocking. It seems like they should have to prove that they were driving unsafely. Do you guys also find that shocking? I find that shocking. Seems like that should be required.
To prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol.
There you go.
Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person.
So what this is, just to break this down, try to make it a little bit simpler. The way that the Massachusetts has this charging scheme, right, is that when it comes to this first charge for count 2, they have two ways they can go about it, they being the jury. They can go about it either by saying, was the defendant under the influence or not? And under the influence is like, were they acting, well, you guys just heard all the elements, right? It's kind of like dumb because it's like they don't have to prove that the person's faculties were actually impaired or what have you, but like basically, rather that they were driving unsafely or what have you, but just simply like, in other words, the jury could, if they go the first route, the jury could find that somebody is guilty of this if it's like, okay, their faculties seemed impaired, they seemed under the influence. It's totally a perception thing. It's very subjective, right? For example, let's just say that all the testimony at the Waterfall from all the people around Karen was like, yeah, she was slurring her words and she was falling over. Now, thankfully, that's not what we heard. Everybody said she was fine, right? However, Karen, in her own words, said she wasn't totally sharp, she was impaired. So there you have a split. You could see how that could be one thing right there that the jury, now again, this is totally separate and apart from, we haven't even gotten to John O'Keefe. This is just in terms of going step by step with these convoluted instructions and with the elements of each charge. If they go step by step, you could see how they could be still starting with and stuck on this very first one, because it's like, okay, well, how do we determine it? Are we going to go off of what Karen said about herself? Or are we going to go off of what everybody else said about her in terms of were her faculties impaired? That's the first thing. Now they have a second theory of how they can go about it, and that's what she's about to explain. And that one has to do with the blood alcohol level of 0.08. Does that make sense, guys? You see why this is, and this is still just the first part of count 2. And I think there's like 5 altogether. So
This blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they
wantonly or now we're getting to the part of her driving the car. Lastly here, now we're still on the first part of count 2, right? This is the part that actually has to do with her operating the vehicle. Okay.
Nor the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured.
Indifferent counts as wantonly or recklessly.
It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent, even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle, the condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous
There we
sequence,
go with the cause of death.
results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss.
So here's what we still have wanton or reckless, okay? But just to be clear, it doesn't say intend to cause the death. It says intends the conduct that causes the death. So again, we're still kind of going along lines of a chain of events here.
Following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death.
Wiz, that's the problem with this shit. It totally could. It absolutely could. The thing is, when you look at these instructions and you break them down, you could it is fucked up as it is. You could totally see how if somebody's been drinking and the jury decides that they are under the influence, right? By any means, whether it be from BAC or whether it be from observations of people around them and whatnot, right? We've just heard a bunch of other ways that the jury can find it. If they find that and that the person was driving and that they have made an action, so let's say that the action was that Karen decided to drop him off with Higgins, right? And then that's a chain of events where then Higgins kills, you see what I mean now, as crazy as it sounds, technically speaking, basically anybody, if you're in Massachusetts and you've been drinking, you could be charged with this type of shit for stuff that you had nothing to do with. You know, in other words, it's like you could even, if you try to really trace it all the way back, it's like, well, what about Karen Reed's parents? Because they gave birth to her. So they set in motion the chain of events that then led to her becoming a person, which led to her becoming an adult. I mean, you see what I mean? This is so crazy to me and ridiculous. So yes, technically speaking, looking at these by the element, 100%. If you break it down literally, the way it's being described and the way the elements are outlined, it's a chain of events. If she started that chain of events, regardless of what happens after, the jury could find her responsible. Isn't that wild?
A defendant's act is the cause of death where the act in a natural and continuous sequence results in death and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor.
So this should be the third of the lesser includeds.
Also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third,
so far, all of these were the same charges as last year. And the reason I'm saying that is because my understanding is that there's going to be an additional charge or lesser included rather after this one that the defense requested. Okay.
That while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the fourth element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use
So a
due.
good way to think about how this is a distinction from the other two for count two is because we've got a different standard. We've got wanton and reckless versus negligent. Okay, so she's going to define negligent now. So not as bad in terms of, essentially the potential time that one could be facing, right? Because negligent is not as bad as wanton and reckless.
Care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant...
She specifically says our law requires that each person that's driving operates their vehicle with a, objectively reasonable behavior, right? Objective, she uses that word. But in determining what is objectively reasonable? The definition outlined in the jury instructions is just, would it be what a reasonable person does? So it's sort of like the snake eating its tail. You know what I mean? Like, it's not objective if you can't define it. Anyway.
Drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser
I mean, this is why you don't just do it the way she does it. This is why you you first of all have a draft, and then you have like another draft, and then you have like a final copy, and then you proofread everything, and then you do another final copy. Like, this is just embarrassing.
Liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, and the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So The third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death.
In case you guys missed it, this is the third count of the 3, and it's the only one that literally uses the word collision as a part of the elements.
Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right. So I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous to reach an unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
Now they're picking the jury.
Yes.
Could the juror sitting in seat number 13 step down and take your place as an alternate? Could the juror sitting in seat number 7 step down and take your place as an alternate? Juror 6, could you step down and take your place as an alternate? Juror 17, could you step down and take your place as an alternate? Juror 2, could you step down and take your place as an alternate? And Juror 8, could you step down and take your place as an alternate?
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree that you not suffer any person to speak to them, and to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged of their verdict, except by further order of the court, so help you God. Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
Jared, make sure you take your notebooks with you.
Okay, so now we're going to jump to today.
Morning, Ms. Reed. Good morning, jurors. Good morning, alternates. So I have to ask you those same questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their head. So, Mr. Foreman, with that, we're going to send you back out to deliberate. Okay.
All rise, the court, please. Follow me.
Officers will give you instructions on where to be and no more than 10 minutes away, okay?
Your Honor, with regard to the version that was sent to the court.
I don't, the version of whatever I have not yet read?
Correct.
Okay.
No, I want to flag for the court. We'd like to replace that. We noticed some errors. There were different versions that were circulating amongst our team, and we believe the incorrect version got filed. So we would, if you have 10 minutes, we can file the correct version.
Okay.
Shocker.
Has the Commonwealth seen whatever it is that Mr. Iannetti's talking about?
I just received it in the courtroom. They may have sent it earlier. I just looked at it a couple minutes ago, so I need some time.
Okay.
We'll make sure he has the updated version as well.
Okay. All right. Thank you.
All rise.
In the courtroom? Is that what's happening, guys?
Long day, I'm going to send you home. So I do have to give you those cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful with your social media use. And I think what's a good idea to do is when you leave here, just leave the case here. Literally, figuratively, just clear your heads. Beautiful day, get some fresh air, and we'll see you
This is the end of the day.
Thank you.
All rise.
There you go. So guys, will we get a verdict tomorrow? Time will tell. There is that motion filed from the defense. I don't have that yet, so we'll go over that tomorrow, but it's a motion that was denied for them to update the verdict slips to make them more clear. Not surprising that Judge Bev flat out denied it without hearing argument. But again, I'll grab that so we can have that tomorrow. But that'll be it for this one, guys. Flash, I hope that you get it worked out with whatever's going on with that troll in Discord. I hate that for you. But as always, I love you guys. Thanks so much for being here and being an awesome squirrel. And we will be back hopefully tomorrow with hopefully a verdict. But for now, squirrel out.